finally, various resources were shared with you all prior to the live prior to this webinar. It is recommended that you view those materials as a supplement to this webinar. So there's relevant, there's power and control wheels, there's different resources that the panelists recommended that you all use ahead of time. So if there are no questions, okay, so I'm going to start off with a brief introduction of each panelist. To start us off, I wanted to introduce Angela. Angela Sequin is the Executive Director of the Domestic Violence Coordinating Council. She is a certified victim advocate and domestic violence specialist with 26 years of experience in higher education, 20 of which were at the University of Delaware coordinating victim advocacy services, prevention education, and the 24/7 helpline sexual offense support. She is the Vice President of the Board of Directors for the National Organization for Victim Advocacy, NOVA, and is a core founding member and advisory member of UD's Center for the Study and Prevention of Gender-Based Violence. Her work is grounded in trauma-informed practices, the empowerment model, and the socio-ecological model and social justice. She loves dogs, music, and dancing. So if everyone could give a nice virtual welcome to Angela. And now I'm going to introduce our next panelist, Erica Davis. Erica Davis started her career in domestic violence victim services in 2006. With experience at Child Inc. and as a legal advocate in Maryland, she returned to Child Inc. in 2015 as the Associate Director of Domestic Violence Services. In 2020, Erica joined Delaware Family Court as the Domestic Violence Coordinator, leading court improvement initiatives and acting as a liaison. She co-chairs the Delaware's Domestic Violence Task Force and the Victims' Rights Task Force Day of Remembrance. So if everyone could give another virtual welcome to Erica. And then our last panelist of today is Laura Graham. So Laura Graham is the Deputy Director at Community Legal Aid Society, Inc., CLASSY, and the Project Director of the Immigration, Domestic Violence, and Medical Legal Partnership Programs at CLASSY, with extensive experience since joining in 2006. Her focus includes immigration petitions for victims of violent crime, domestic violence, child abuse, civil relief for survivors of domestic violence, eviction defense, and medical legal partnership program collaboration with healthcare providers. And that is our last panelist of today. So yeah, I'd love to see those clapping hand emojis on everyone's screens. So as you can tell, we have a great panel. Like I've seen in the chat, a panel of experts. So I'm super excited to be welcoming the three of them today. And let's jump into our questions. So can you provide a brief overview of Senate Bill 70, Senate Bill 71, and House Bill 151 and how they specifically impact protection from abuse orders in Delaware?
Sure, I'll take this one. So SB 70 and SB 71 were part of a 3-bill package that was introduced in 2023 and signed by the governor, I think in June, to address animal cruelty, because as research has shown, there's a link between animal cruelty and family violence. And Delaware, like many other jurisdictions, really wanted to address that link to protect Delaware's children. So SB 71, although it's not directly connected to PFAs, was critical in that it requires law enforcement, DFS, and the Department of Justice to report animal cruelty when it's discovered in the course of their duties responding to child welfare cases. SB 70 and House Bill 151 is going to be more the focus of this panel discussion. SB 70 was the PFA bill that modified the definition of abuse to include abusive acts against a person's companion or service animal, namely engaging in cruelty, inflicting physical injury, and engaging in a course of conduct that is alarming or distressing to the petitioner. SB 70 also gives the court the authority to include provisions in PFA orders that grant a petitioner exclusive care, custody, and control of a companion animal, and can order a respondent to have to stay away from that companion animal. House Bill 51 was introduced in the spring of 2023 and took effect in December, and it also modified the definition of abuse in the PFA statute to include the intentional restriction of another adult's access to economic resources resulting in a loss of financial autonomy. Specifically, this means maintaining overwhelming control over a person's financial resources, withholding access to money or credit cards, forbidding attendance at school or work, stealing, defrauding, money or assets and exploiting resources for personal gain. And so this act also codified the court's existing practice to order a respondent to return legal documents to a petitioner. And legal documents could be things like birth certificates, passports, immigration information, banking information, stuff like that. And so although they were addressed in other ways in PFAs prior to this legislation, this really solidified and codified those acts of abuse.
Thank you. I couldn't tell if Laura was reaching to unmute or not, so. And I'd love to follow up and ask, what are some examples of reportable abuse to animals?
And I will take that one. So, very similar to child abuse, in addition to signs of physical abuse that you might detect, signs of neglect or environmental concerns that might suggest that there has been abuse happening can be reported. And the Office of Animal Welfare recently created an infographic that I'm actually going to share really quickly with you all. No, I'm not, because that's disabled. But it is in your resource packet that is linked in the chat that Francisca provided. But it's lovely. It looks like this, and on the back, it has a list of examples. And those examples include things like extreme thinness and emaciation of the animal, open wounds, broken bones or injuries, weakness or the inability to stand, skin conditions that have gone untreated, infestation of fleas and ticks and parasites and things like that, extreme fur matting, overgrown nails that make it difficult for the animal to walk, a collar that's embedded in their neck, confusion or lack of responsiveness, being outdoors for long periods of time, not being provided adequate water and food, not having a shelter but being exposed to the extreme elements and temperatures, um, a lot of trash, debris, feces, or urine in the area that the animal's enclosed in. If they're permanently in a cage or chained up, or left in the car or garage or attic or basement places that have extreme temperatures. And then overcrowding, if it's many animals being kept together in kennels or crates nonstop. So how to report animal abuse is also on that infographic, but you basically contact animal services. The Office of Animal Welfare has a great website at animalservices.delaware.gov, and they have a phone number you can call, 302-255-4646, to report any of these forms of abuse. And I wanted to add that SB 71 also included immunity, so anyone who makes a good faith report where they believe the animal is being abused, they won't be subjected to any sort of civil or criminal liability that they might otherwise exist if they reported. And then finally, I wanted to add that with the PFA provision, the petition cannot just include forms of direct abuse to the animal, but ways that the animal is being used by the abuser to control or coerce or harm the victim. So things like harming the pet as a means of demonstrating the violence they're capable of using on the person, whether it's the partner or the child, injuring or killing a pet to hurt the person who loves that pet, threatening harm as a way of having coercive control to get the victim to do what they want, or exploiting the victim's love of the pet to either get compliance or to make it so that the victim won't report or leave or seek a PFA or any of those pieces.
Thank you. And I just wanted to make an announcement. I think our interpreter has dropped off the call. I'm not sure why, so I apologize for anyone using the interpreting services. We're trying to get her back onto the Zoom call as soon as possible. I believe if you need the webinar in Spanish, you can make the captions in Spanish, but I'm not sure how reliable those are, so we are trying to get her back onto the call. But thank you, Angela. I also linked the animal abuse infographic that she was referring to in the chat, as well as the resource guide that was included in the email. Okay, So the next follow-up question to that first question about the overview is, what are some more examples of economic abuse? I know Erica covered a few in her response, but I'd love to hear some more examples of what economic abuse could be classified as.
Absolutely, and I can take that one. And so as Erica and Angela both mentioned, these kind of fleshing out of the definition of abuse really are grounded in power and control. And it's one family member using that power and control over the economic means or access to necessities of the potential petitioning partner. So it can be anything from withholding money to cutting the survivor off from a bank account, not allowing access to an EBT or a food stamps, electronic benefit card, health insurance cards. It can be withholding or retaining documents, regardless of the survivor partner or survivor family member's immigration status. But it's particularly controlling if the survivor is a non-citizen. Things like work permits, passports, documents are incredibly important and can limit an individual's ability to work and seek independence financially. So again, the idea behind HB 151 was to really codify what historically advocates have called any other acts that a reasonable person would find threatening or harmful. It just really lays out for advocates and survivors what economic or financial abuse or exploitation is, so that they can indicate that in their petition.
Thank you. So what enhancements or changes do these laws bring to the legal protections available for survivors seeking protection from abuse orders?
Well, Francisca, I think one of the main things is it really, as I just mentioned, lays out for petitioners and advocates what counts or what will be considered as abuse. Many individuals think that they're required to show physical abuse, and that is not the case. That's one of several ways a person can be victimized. And so what the family court has done is edited the PFA petition. So it really lays out and asks prompting questions of the petitioner, of the survivor, about different types of abuse, including animal abuse and financial abuse or exploitation. So we know that most petitioners for PFAs in our state are pro se, meaning they don't have an attorney representing them, unfortunately. And so what this does is it helps advocates and petitioners who don't have an advocate really articulate what types of abuse they're alleging have happened. And the reason that's important is because the courts, for due process reasons, require a petitioner to plead well, be specific about what they're alleging so that the other party has the ability to respond. They know what's coming and they have the ability to respond. And so if you don't lay out in your petition what economic abuse or animal abuse you've experienced in your relationship, then you can't raise it at trial. So if a judicial officer is asking those questions based on these new enhancements to our PFA law, if they're not in the petition, and specifically the petitioner didn't plead them or state them in the petition, it's not going to be allowable at the hearing. So the idea in updating the petition is so that survivors can articulate with specificity what has happened to them. And it prompts them to think about animal abuse and economic abuse as two ways that they may have been victimized.
Right, so what you're saying is it's made more explicit with these new bills, because before it was more of a abuse, like all abuse, but maybe having it more explicit, well, definitely having it more explicit will allow people to more specifically ask for relief. Absolutely. And so this was actually a question from one of the participants, one of the registered participants. Are there provisions for the expensive care and upkeep of companion animals or service animals?
So in terms of HB 95, which is the bill that allowed judges in family court to consider animals when they're, going through the process of the divorce proceedings and custody, because Delaware's a state that considers animals property, then they could consider for the first time, they could, and in fact, because of HB 95, judges now have to make a determination if animals are raised. The key point is if the court finds that a companion animal of the parties is marital property, then it can award ownership. The court may find in a case that that animal belongs to one party and not the other. But they in any of those situations, yes, that can be a part of what is found in I'm missing the word that I need right now, but that's okay. In terms of the PFA, I don't know that costs for expense, the expense and care and upkeep of the animals would be part of the PFA, but I'm just going to reflect back what Laura just said, that if the petitioner hasn't included the request around the animal in the petition, it can't be considered on the day of the hearing. It has to be included. But Erica, you or Laura may have thoughts about the cost piece for PFAs.
I think even prior to this legislation, if somebody were awarded use of, I don't know, possession of an animal as they would have been in 2022, we'll say, they could ask for, in the same way that they could ask for spousal support or temporary child support, additional compensation to help maintain a home, care for a pet, etc. I think that that's always existed, and it's just spelled out a little more clearly now. But no, I mean, a PFA doesn't have a place on there to check relief specifically for care of a companion animal, but I believe it could still be included.
And I would, I think it's akin to asking for possession of the family home or rental unit and asking the court to consider ordering the respondent to pay the mortgage or the rent for a set period of time. So, conceptually, I think it's reasonable to include that type of request as long as you have the facts and the documentation to back up what you're requesting.
This is a really good segue into the next question that I have about communication of these new provisions to clients. So, how can service providers effectively communicate the new legal provisions to survivors, ensuring that they are aware of the available resources and protections? And you all kind of touched on this about, especially for people who are pro se, advocating or representing themselves. But definitely, how can service providers communicate these new provisions?
So I think we did touch on it a little bit, and I'll just expound a little bit more. One of the things that I would suggest, one, being here is helpful so that service providers themselves are aware of the changes. But Family Court's website provides a lot of information that's especially helpful for both self-represented litigants and anyone, advocates included, who are seeking information about court proceedings, filings, and information and access to updated forms. All of the printed materials that are available both online and in our family court resource centers have been revised to include the legislative updates. So service providers should be themselves aware of the changes, but then they can also direct litigants to these resources for additional info and support. But additionally, and I think Laura mentioned this, that on the PFA petition forms, each type of abuse is separately listed and explained, and it prompts petitioners to include any information about separate acts of abuse that fall under each category. And so I think as a service provider, it's really important because often survivors of intimate partner violence won't recognize behaviors as abuse until it becomes physically violent. So helping them recognize that these other types of coercive behaviors that seek to help someone seek to gain control over the other person is actually abuse and should be included in their petition. and giving them help in constructing or filling out petition forms that includes all of the acts of abuse that have occurred that the petitioner will want to speak about in court. I know Angela touched on that a little bit, but including that information with as much detail as they can, with dates and locations at events that happened, so that they can talk more about that in hearings, is really helpful. But then also in the section of the PFA petition where petitioners can check boxes on the type of relief that they're seeking, there are options to request exclusive care, custody, and control of a companion animal, and order the respondent to stay away from that animal, and places for petitioners to list specific legal documents that they want to have returned to them. So just directing survivors to that information and helping them fill out petitions in the most meaningful way possible.
And I just wanted to point out that in the resource guide link that I provided, the petition form is actually included in there. So if you wanted to look and see, in case you haven't seen one before, if you haven't seen the form before, it is included in that resource guide so that you can look at the different sections that Erica has been talking about. The next question is kind of going in a little bit of a different direction, but I wanted to know, how do these laws address the needs of diverse populations, including those from marginalized or vulnerable communities?
I think Angela and I are splitting this question. So, I mean, much of this we've already touched on. I mean, I think talking with folks about the different types of acts, controlling, coercive acts that constitute domestic violence, educating the community, regardless of age, regardless of national origin, regardless of relationship status, about what is domestic violence and what protections are available, is crucial. And that includes language appropriate materials, which the Family Court has done a good job of providing materials in English, Spanish, and Haitian Creole. And so I think using those materials and connecting survivors with trauma-informed, culturally appropriate, and linguistically appropriate providers and community partners is crucial.
And so in terms of the animal abuse updates, adding animal abuse to the PFA provisions really supported the needs of people with disabilities who might be petitioning, whether they have a physical disability, mental or physical health concerns, or the elderly who rely on service animals to get through day to day. Whether that's seeing eye dogs, dogs that alert the hearing impaired, emotional support animals, animals that provide detection for seizures and low blood sugar, animals that remind people to take their medications or that help with anxiety from PTSD. So the other thing I just wanted to mention here is that the National Center on Domestic Violence reviewed various studies that have been done over time related to domestic violence, and found that 20 to 60% of domestic violence victims delay leaving their abusive partner out of fears around the animal. They're fearful of harm to the animal, losing the animal being killed. One study estimated that 40% stay because of the pet. So including animals in the PFA means that it really acknowledges the importance of animals in the victims' lives, and even honestly, the importance of animals in the healing process. It is our hope that more victims will seek a PFA and other resources because this is available.
Yeah, thank you so much for sharing that. I know for me, when the animal abuse protections and provisions were announced, that made my heart very happy, because I know that your animals and pets are a part of your home, like they're a part of the family. So thank you for explaining that. I wanted to follow up. This has been kind of part of the conversation this whole time so far, but especially for survivors representing themselves, how can advocates in the community best prepare petitioners for court?
And I can take that one, Francisca. I think, as I mentioned earlier, only about 25% of PFA petitioners have representation, which means 3/4 of folks are going at it alone. And so I think advocates in the community are really crucial to helping us bridging that access to justice gap until we have a day where there's right to representation in PFA cases. We're not there yet. So I think one of the things that I touched on earlier, making sure it's a very detailed petition, for each specific question about physical abuse, as Erica mentioned, the petition, the fillable form for the petition tracks the statute. And by that, I mean, Section 1041 lays out different kinds of abuse, including now financial abuse and abuse of an animal. And so in each of those sections, encouraging the survivor with whom you're working to provide detail. And I'm not talking about, 5 pages of single-spaced paper, although that does sometimes happen. What I'm talking about is kind of the who, what, where, when. So on date, respondent did X to Y. Giving enough of a foothold for the fact finder, the judicial officer, to show that that's the incident you're talking about, and to put the respondent on notice that that's the incident or the group of facts that you're talking about. It can be time consuming, and most humans don't think in a linear kind of bulletin list chronological fashion. So making sure that an incident that involves physical abuse, perhaps of the petitioner or the petitioner's child, and then includes abuse of an animal, that it's listed in both of those sections, and that the facts stick together, that they're credible, and that they check out in both sections. But again, I think if nothing else sticks with you from today, making sure that there's specificity and that time is spent working with a survivor and filling out a petition to make sure all of those points are addressed, so that they're as prepared as they can be if mediation fails and the PFA goes to a trial.
And I just wanted to add that there have been vacancies at the Domestic Violence Advocacy Program that is housed in the courthouses. And that makes it, I think, all the more important that advocates like you all who are on this call be able to provide some of that assistance.
And Francisca, if I may, just because I'm a little slow in catching up with the chat questions, one of the questions in the chat talked about with financial abuse, a respondent changing passwords or disallowing access to a bank account, a jointly held bank account that way. And for those of you who are my age or older and you know what a checkbook is, this is the equivalent of the respondent hiding a checkbook or hiding the credit card or cutting it up. I would argue that disabling the app or changing a password to lock a petitioner out of a banking app or a healthcare app or something like that, that the petitioner needs to live, is the same thing as shredding a checkbook. They don't have access. And so again, to get back to the petition indicating on date, I was told by TD Bank that respondent had changed the password on our joint account and I could no longer access funds to be able to get food, diapers, etc. For myself and the children. Doesn't have to be long, but just enough to stick a pin in it for the court to show this is what I'm talking about and this is why it qualifies under Section 1041.
Yeah, thank you so much for addressing that from the chat. I was gonna wait until the end, but you are a go-getter. So we have one last question from the set of panel questions. We are going to allow time for live Q&A, and we also have still some questions that you all submitted. Thank you so much for submitting them. So my last question is kind of looking towards the future. How can the legal and advocacy communities work together to continue addressing the evolving needs of survivors? And I'm going to let everyone answer this one.
It's a battle of who unmutes first. I mean, I would say participating in events like this, the Coalition Against Domestic Violence, the Domestic Violence Coordinating Council, there are various groups that put on, both from a state standpoint, but also a national standpoint, webinars, CLEs, training events. But I would also say part of learning about updates or communicating need that isn't being met or being addressed is being active in things like the task forces, engaging with other advocates. And if you see something that's not working, or a need that's going unmet, saying something, and working within the frameworks that we have in place in Delaware. That's one of the things that's great about working and practicing in Delaware. It's a small and tight-knit community, and it's a great way to join the fight and effectuate change. So I would give a strong plug for being an active participant in the task forces and other community-based grassroots work.
So I'm going to echo Laura's plug because the task force, the DV task force and the victims' rights task force are a great resource for networking and collaborating. And it brings together all of the organizations who respond to victimization in Delaware. The DV task force meets monthly, and we have a standing agenda item to address trends and issues that are impacting victims throughout the state. I mean, and those conversations that are held with the coalition and within the DVCC are how legislation like this moves forward, because a need is identified and then work is done to address it. And so the task force is a really easy way to bring to light issues that your clients are facing, for you to troubleshoot issues, bounce ideas off of others, and talk with other agencies about what you're seeing and how we can fix a problem. So if anybody on the call is not yet a member of the DV task force, we certainly welcome you to join us. I'll put my information in the chat and add you to the listserv. That way you can get updated information about services that are available and notice of meetings and other events. So thank you, Laura, for that.
Well, it's hard to top that. But what I'll add is that I think communicating with each other, whether it's through the task forces, by coming to the Domestic Violence Coordinating Council quarterly meetings, but communicating about what's going on, I think that the trends, finding places to talk about trends is really important, so that we know. Recently the sexual violence protective orders were put into place, and it was through those kinds of group discussions where we started to identify some issues that are now being able to be addressed. So letting each other know when there's a need, and if there's a fix that's needed in the policy, being able to talk about that and advocate for that. And when we have bills like the ones we're discussing today, please come to Legislative Hall and make public comment as an advocate, as part of the advocacy community, to say why it's so important that that bill pass and how it will directly benefit survivors.
That was,
I'm sorry,
go
go
ahead,
ahead.
Eric. I was just going to say that was one of the questions, is how to get involved in further advocating to the public and legislators. And I was just going to add on or just echo what Ange was saying, that you can go to these committee meetings. They're all public meetings on the public meeting calendar. You can go and watch session. And that's one of the ways that I started getting involved, because I didn't understand the process at first, but that's knowledge is power. And I sat in on a lot of those committee meetings last year, and it really helped me understand what was being passed, what was being talked about. Erica?
And so these are all big picture solutions or ways to find solution. If there are anecdotal issues that you're facing, especially related to PFA, since that's what we're talking about, PFA legislation, as the DV coordinator, one of my roles is to act as a liaison between family court and its stakeholders. So if you're working with a client who has questions about a PFA proceeding, needs information about a court date, needs copy of an order that their support animal has eaten, please reach out. My contact information is the same, and I will certainly be glad to help with that.
Thank you. So that is the first portion of this panel. We have about 20 minutes left. There are some participant questions that I have here. I don't know if any of the panelists had any ones that they had wanted to address that we haven't touched on yet. I have a few starred here. I see Angela unmuted, so.
Well, I just wanted to say that that next question that came up in the chat, if we make a report, but the animal services disagree with the claim, then what do you do? I don't know the answer to that, but I have two thoughts. I just emailed the executive director of the Office of Animal Welfare. I'm hoping she sees my email before the end of the webinar and gets back to me with an answer. But my other thought is continue to report. If you're continuing to see signs of abuse, maybe that first allegation couldn't be validated or couldn't be, there wasn't substantiating evidence. But if abuse is continuing, I would keep reporting it because that's going to continue to initiate investigation of it.
I love when you email people during, like, I don't know how you do it. And your grammar and spelling is always great too. Okay, I did have one. I thought this was an important question. When will these changes go into effect? So that was a question from one of the participants. It's a good
So
question.
the animal abuse legislation went into effect on June 27th of 2023, and the economic abuse was added on December 20th. So they are in effect.
Good question to whoever submitted that one. And there's also a question in the chat. Is there a statute as for how long this must have happened? Long ago, this must have happened. Client is since divorced, but these were not reported. Client is now displaced and had to file bankruptcy by the time she received advocacy services. Still ancillary matters pending and issues providing for children because of this from 2020.
That's a loaded question, Stephanie. So, I mean, I think speaking from a PFA standpoint, there is no statute of limitations on, how long ago an event occurred to seek a protective order. But I will say that the whole point of a protective order is to provide safety and separation and protection to a survivor. And so there's some level of urgency that is implied and required with seeking a protection from abuse order. So, if something happened 10 years ago, is it per se not allowable to be raised in a PFA petition? No. But is it likely that a judicial officer is going to want to hear about something that happened a decade ago that was abusive? Probably not. So I recognize that's a very lawyerly answer, and I apologize. I think separate and apart from protection from abuse orders, if there is power and control happening in property division, ancillary relief, and that would only apply to a married couple, then there may be ways to raise that there because it's about equitable distribution. And if one party is engaging in power and control and defrauding the other party, then I think by default it's not equitable. So I guess the short answer to the question is no, there's no statute of limitations for when any of the types of abuse listed in 1041 occurred to be eligible for a PFA, but it's the whole point of a protective order is to provide immediate safety and protection, including some shorter term things like use of a home, custody and control of a child, to kind of manage that relationship as the parties stay apart. So the more recent and more urgent the incidents of abuse, the more relevant. I don't know, Erica, if you want to add anything from the family court perspective to that?
I think that you gave the best. I can't improve upon your answer, so thank you.
Awesome. Another question that was submitted before the webinar that I'd like to address is if a survivor is confused as to what they may qualify for, what is their first port of call?
Can
Yeah,
you repeat that? I just want to make sure I understood your
Yeah,
question.
I can repeat it. If a survivor is confused as to what they may qualify for, what is their first port of call?
Well, being an advocate, I'm going to say that they should always be referred to an advocate, whether it's the DV hotline, where they can get information, work with somebody immediately on safety planning to talk about what their options are. I think that's going to be their best course of action to start with. And then from there, the hotline counselor can give them direction on whether or not they want to talk to somebody within the court-based advocacy program to file a PFA or make a referral to Class E or DVLS. But just somebody that can talk to them about all of their different options. First and foremost, their safety, and then build from there.
And I would say too, for individuals who aren't ready to make that human contact, um, and they just want to do some information gathering in a safe, quiet way, connecting them to the national network, to the DVCC website, to the family court website, where there are written materials, infographics, and videos that someone could read or watch to just get information and see what they might qualify for. So they have that background, and then when they're ready to reach out to the hotline and speak with an advocate, they're already empowered with some knowledge.
And in the Google Drive folder that has been shared with all of the participants, there is a helpful links document that has links to the family court website, and I can add some of those national resources that you mentioned, Laura, too. So I'm going to open it up to the participants. I think probably the best way to do this is if you have a question, if you could put your question in the chat, and I will read them out loud to the panelists. Or maybe they covered everything so perfectly, no one has questions.
Well, so to that question that was asked ahead about how do I get involved in further advocating to the public and with legislators?
Hmm.
Um, a lot of the opportunities that come up or the calls for advocates to be involved come via the task forces. So again, if you are not already engaged with the task forces, that's a good place. Or the coalitions put out a lot of word to their membership about the need for legislative advocacy. And you already mentioned, I think, Francisca, that most of those meetings are public. So if you go to legis.de.gov or whatever it is, that, on the Legislative Hall website, every day there's a list right on the homepage of what that day's meetings are and what bills will be discussed. So it's really not hard to follow. The trick is, making the time in your schedule.
I just put the link to the Delaware General Assembly's website. So I think one of I didn't understand this. You don't have to go to Dover to advocate for something you're passionate about. You can call in and give public comment. So if you're not able to get down to Dover, that is another way that you can advocate for different legislation. And that link also, you're able to look up different bills by bill number. So if you wanted more information on any of the bills that we talked about today, all you have to do is type in SB 151 and who sponsored it, all the different actions that were taken on that bill show up, and all of that was also linked in the Google Drive as well. There is a question in the chat. Are there shelters who would take animals who are victims?
That is what I unmuted to share, that the Brandywine Valley SPCA is a partner with Child Inc. and has agreed that even currently, so there's a national agency called Red Rover that provides grants to shelters so that animals can be sheltered when human victims go into domestic violence shelters. And even though that grant has expired, in Newcastle County, the Brandywine Valley SPCA has pretty much agreed that they'll temporarily take on animals until folks are done with shelter. And I know that at one point, People's Place also downstate also had a Red Rover grant. And I have to clarify this with Blanche, but I think that they even currently take, yeah, there we go. Thank you, Blanche. That they also have funding for sheltering.
Great. And I see in the chat, Marianne shared the LEAP email list. That's where I think another resource you can get legislative updates as well and different calls to action. So maybe some of those letter signing campaigns. There's different ways to take action. You don't have to always go to a committee meeting or go to session to get involved.
Red Rover has a great campaign going on right now, 25 by 2025. Their goal is that 25% of shelters will be able to also shelter animals by 2025, and they're already well on their way to reaching that goal.
Yeah, and it looks like there's a follow-up question in the chat about shelters. Do you have to be a victim of domestic violence to qualify for those shelters?
You do for the domestic violence shelters specifically, but there are other shelters for people who are experiencing homelessness. And I believe that somebody can fact check me on this, but I heard this recently that the Hope Center in Newcastle does allow pets. They allow people to bring pets into shelter with them on a temporary basis. I have not investigated that, so I could be spreading fake news. But thank you,
Someone
Jess.
said in the chat they do allow pets. You're getting some validation in the chat.
I'm fine.
And hi, everyone. I'm Brooke Allison from Martha's Carriage House. So can I just chime in and say that our residents that come to shelter here, we just recently got back into a contract with the SPCA, who does house their pets for them during their stay here.
Thank you so much for sharing that. That's very helpful. There's another question in the chat. Does anyone have any success stories recently or any feedback on how it's been received by commissioners when included?
Sure. I mean, I can take that certainly. I mean, I've seen petitions asking for placement of an animal after alleging the respondent engaged in abuse of the animal and the petitioner. So we've definitely seen successful ordering that relief. I think with financial abuse stemming out of HB 151, we've always, when we've been involved and when DVLS has been involved, we've seen requests related to return of immigration documents or return of children's birth certificates and social security cards, et cetera. It's just more importantly, I think, is the success for pro se petitioners. And because pro se petitioners by default don't have representation, I don't know the answer to that question, but perhaps Erica can share kind of anecdotally what she's seeing in orders with pro se petitioners getting that kind of relief.
So the orders that I've seen, like you said, Laura, they contain language that I think has been there a lot in the past. But I think how HB, is it 151, has been most impactful is that it puts a place on the PFA petition for petitioners to really draw out what that coercive behavior has looked like around their economic needs and economic abuse, whereas it wasn't spelled out as clearly before. So the relief is still there because people would ask for it in different ways previously, but now petitioners are prompted to include details about that type of abuse, which has been very helpful.
I also thank you for answering that question. I wanted to point out in the chat, somebody asked if this webinar will be available. Yes, it'll be available on our YouTube channel, on the Domestic Violence Coordinating Council's YouTube channel. I will make sure to let you all know when it's available and uploaded for you to share with people that were not able to make it today. So we have about 5 minutes left until 4. The time went by very quickly, but I feel like we've gotten a lot covered. Are there any other questions that you all have that you'd like to put in the chat before we end the webinar for today? Or is there any last words that the panelists wanted to share before we ended for today?
I wanted to highlight what Carolyn Becker said in the chat because I think that that's really an important consideration. She said that I also want to give a shout out regarding the Immigration Committee of the DVCC, as well as the Latino Immigrants Victims of Crime Working Group of the Victims' Rights Task Force, because there are cultural differences in caring for a pet that need to be talked about and disseminated around the communities, and people living in the US from other cultures learn about laws around caring for pets. And I think that cultural consideration is really important, an important piece for advocates to be aware of.
And that is one of the spaces where providers, some of which I see on this call, do share what trends they're seeing with the survivors that they work with. So that is another opportunity for those that are interested in advocating for specific legislation or policies or changes to check out some of those committees or groups that are being mentioned in the chat. Okay, I'm not seeing any other questions, just compliments. So thank you all for those. But thank you all so much for joining us today. I hope everyone gets home safe. I know some of the sidewalks and roads are still a little bit slippery here, at least in Wilmington. But thank you all so much for joining today, and stay tuned for the recording, and I'll also be sending a follow-up email with resources.